Did I play the clarinet? Is that fun? How do I hit the button? I'd say get out in the mountains and enjoy myself out in the mountains. Helicopter pilot or bush pilot in a little float plane. That'd be all right. I mean, I don't know if it's from the legal perspective, but the fact that it deals with campus free speech is what it made it so significant to me. Um, the point we've been trying to make to the court, and we are hoping to make to the court, is that we live in a democracy where we do things like search for truth and freedom, and we have open discussions about public policy. And one of the locuses where we do that is on the university campus. So if we don't have free speech on university campuses, we seriously handicap our ability to function as a democracy. Or we require that people basically abandon universities as a place to have those kinds of conversations, and therefore just really waste those institutions. So I think that free speech on campus is just a hugely important thing for Canada, and that's why I think the case is significant. We're kind of early on, unfortunately, in the file right now, but one of the major challenges I face is just procedural hurdles, kind of crazy procedural hurdles. They've thrown up some arguments, and the court has bitten on those arguments, and so we find ourselves having to run to the Court of Appeal on things that really we shouldn't be running on. Our preference would be to get to court and deal with the subject matter at hand. But the first thing we have to do is deal with some procedural issues. But those raise some very interesting legal questions that are also important for Canadians. So I look forward to arguing those at the Court of Appeal. Well, I'd say that the case is going to provide a bit of a roadmap to universities, especially in Alberta, as to what they can get away with. As it now stands, universities seem to think that as long as they are doing good things, like in their minds protecting people, they can really stamp down on free speech on campuses significantly. So our hope is that what will prove to the court is that the Charter of Rights and Freedoms should apply fully to the universities in Alberta, not just in a somewhat limited sense as they do now. And secondarily, that those charter freedoms, if they're going to mean something, need to mean, especially in a situation like Dr. Widowson's, that she should have the full right to come onto the university campus and speak. And then if there's going to be restrictions on free speech and, to protect people's safety, there's got to be some serious safety hazards that we're talking about, which is not what we're talking about. We're talking about a kind of intellectual safety, which in our view is the exactly what the university is supposed to be doing, exposing students to intellectual danger. Well, I guess two major things. One, again, is that if you look at the relationship now between governments and universities, things have changed quite a bit. Governments don't just provide most of their funding, they're deeply involved in their operations. And one of the challenges we're having in BC, and I hope we don't have the same challenge here in Alberta, is getting the court to understand that given that the government has rolled up its sleeve and decided to get closer into the management of that university, therefore the university really has to be subject to charter scrutiny in everything it does. So that's one thing that we're hoping to do. The other thing we're hoping to do in this file is really get the court to start taking more seriously Section 1. So Section 1 of the charter allows government to restrict freedoms in certain circumstances. And there's a lot of case law, I would say, where there's more or less a kind of rubber stamp that's applied to the government's decision to restrict freedoms. And so one of the things we're really advocating here is let's get more serious about that exercise, and let's make sure we're really giving some careful thought to both the rights at stake and the competing objectives. It falls short everywhere. Um, it falls short in the scope of the right. The scope of the right now doesn't, I mean, it doesn't protect violent expression, which sounds fine. Why should the charter protect my right to hit somebody in the face? But violence is now predictably being redefined to mean things that are really just expressive activity. So it falls short in terms of both what is protected, and again, it falls short in how those rights are limited. Where government decides to limit free speech rights, there is no longer the kind of robust review that was promised by the Supreme Court of Canada back in the early 80s when it first when the Constitution was first adopted, or the Charter was first adopted. And the courts just aren't taking that Section 1 analysis very seriously. Yeah, I would say for me, the most important part of this case is that Frances Widdowson is a person who has spent her entire life in this industry, basically, namely Indigenous policy. So when she goes onto campus, or she acts as a professor and she is trying to exercise her free speech rights, what she's really trying to do is enter into a rational inquiry where all of the options are on the table and there's a clear and civil dialogue about what the best policies are that will help close the socioeconomic gap between Indigenous people and other Canadians. And so to try to silence and censor and impose sort of orthodoxies on that conversation, namely to say we all know exactly what causes it, we all know exactly what the solution is, and so we're not going to think about any other options, we're not going to think about any other ideas, which is basically what she's facing, is just a recipe for bad policy. So there's definitely a recognition in Canada that there's a big disconnect between the socioeconomic status of Canadians and Indigenous Canadians. And I think a lot of Canadians think it's very important that that be closed. The first thing we have to do if we want to close those is have a reasonable dialogue about it. I'd probably say that if Canadians, because they don't want to pay the cost of speaking the truth, don't speak the truth, it's going to become increasingly more costly to speak the truth. So one of the most important things that Canadians can do, in my mind, is when it's unpopular, or no matter how unpopular it is, no matter what kind of names and ugly things that you're going to be called, no matter if you're going to suffer all sorts of damage to your reputation, social isolation, etc., it's every Canadian's duty to always speak the truth and not allow public lies to go unaddressed.